Indian Evidence Act. In this session, we will discuss 4 sections of relevancy of facts chapter. Those are the 4 concluding sections. What it provides? When character is relevant. What do you mean by character? You think for a moment, what is the character of a person? As a layman, we understand character means somebody's moral character. How far is moral in his personal life? But that is not the character as per the provisions of the Evidence Act. When somebody is accused of committing a crime, immediately it comes to your mind whether a person has committed the crime, taking its general character in the society, general reputation in the society. Suppose a person of high repute was implicated in an offense. Sometimes it comes to the mind of a layman, or immediately a opinion is formed that he is such a man of reputation, is a high reputation, having high reputation in the society. He should not have committed, or he would not have committed that offense. Some false accusation is made. That is the common or general belief in the society. But law takes the character or looks into the character of a person differently. Because there is no method, there is no method to find out as to what is the character of a person. What is the character of a person? There is no actual method to find out what is the character of a person. What is the character of a person? That is best known to him. Best known to him. A person appears in one capacity in general public, but his character may be different in nature, in his personal life. So, that's why the law doesn't look into the character of a person. That to come to a conclusion or to give benefit to a person as is a man of high reputation, there should be a presumption in his favor that he is innocent. A law is equally applicable to a wicked person and also to a virtuous person. The man's character and conduct is such, it may change from place to place, time to time, and a person may be a person of good character in a particular circumstances, but he may be of a very bad character in another circumstance. So that's why you cannot say, or it is very difficult to find out what is the character of a person. When it is not possible to know, not difficult, it is not possible to know what is the character of a person. For example, a husband and wife may have a reputation of being a loving couple. To outside, husband and wife are loving couple. Everybody knows that they are in good relationship. But who knows what is their relationship in the bedroom? But a good friend of the family knows the truth. Only the good friend of the family knows the truth. A person's character is one type in the drawing room, to outside. If somebody has gone to a particular person to visit a particular person's house, in the drawing room the husband and wife, they came and they behaved like friendly, as if they are best couple. But soon after the departure of that the guest, they may quarrel. So that's why character is not taken into account by court while deciding cases. The general rule is that character plays very less role in deciding a case. As because a person is a person of high repute, a saint, or he is treated as a godly man, or he has lakhs of people who are following him, they are worshipping him, he would not have committed a particular offense. That assumption is wrong. Such presumption is wrong. If you, I should not name anybody, but you know how the man of very high repute, they are being accused of committing very heinous offenses. And there are also some persons of high repute, even saints, they are in jail. So that's why law has not taken the character into account while deciding a case, except as provided within the provisions of section 52 to 55. There are general rule is that character will not be taken into consideration by the court. Character of the parties will not be taken into account while deciding a case, but character becomes relevant only as per the within 4 sections of the Evidence Act. That is section 52 to 55. 52 and 55, in these two cases, these are civil cases. In civil cases, when character becomes relevant, 53 and 54 provides when character becomes relevant in criminal cases. What section 52 says? So you should know what is character. Character doesn't mean moral character of somebody, but character has been defined in the Evidence Act in explanation of section 55. That is, character means general reputation and disposition, general disposition of a person. Not what is disposition? His behavior, that is a person means his nature to others. So reputation of a person means what is that? The estimation of a person in which the public hold him, that is reputation. The estimation of the public regarding in which they hold him, that is reputation of a person. So that is reputation never depends on the personal knowledge of somebody. That is totally hearsay. A person has a reputation on without hearing it from others. A person's reputation is estimated. But a disposition of a person means his nature, and this can be spoken of only by person having personal knowledge. What is the disposition of a person? That can be spoken of, that can be told by the person who has personal knowledge. But the reputation can be, a person builds a reputation throughout his life. That is how he is estimated by public. That is called reputation. Disposition means the nature of a person. That disposition is not general disposition. That is not known to the public. It is known to the person who has personal acquaintance with that man. So in Indian law, that is under the Evidence Act, the character means both reputation, general reputation, not general reputation and general disposition of a person. But in England, the character, that is only that is a reputation. That is a reputation. So here, let us understand what is character. Character means not moral character. It is the general reputation of a person or general disposition of a person. So when character becomes relevant? Section 52 of the Evidence Act, what it provides? That when character is relevant, what is in civil cases, character to prove conduct imputed irrelevant. So in civil case, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is irrelevant. So you should know, you should remember that in civil case, the character of a person, of a party, is irrelevant to prove the imputation made against him, except in so far as such character appears from facts otherwise relevant. That means that except in so far as such character appears from facts otherwise relevant. Some other facts are relevant, then that is from the other facts, if that character is relevant, then becomes relevant. So what is, so first in civil case, you should remember, in civil cases, the character of a party is irrelevant. But in section 55 provides, in civil case, character becomes relevant when that is necessary, that is to be proved regarding the determination of the quantum of damages in a civil case. You should read section 52 with the section 55. What section 55 provides? Character as affecting damages. In civil cases, the facts that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. Suppose a person has filed a suit for damages, for defamation. If he is a man of high reputation, then that character becomes relevant to determine the quantum of damages which will be paid to him. So quantum of damages or compensation differs from case to case. A person of high reputation, if defamed, then the quantum of damages will be a very high amount. But suppose a person of low reputation, a defamation is there, there may be less amount of damages. So that's section 52 and 50. This 55, you should know, this is the character when becomes relevant in civil cases. Now, so far as criminal case is concerned, there are two sections, that is section 53 and 54. What section 53 says? In criminal cases, previous good character relevant. Suppose a person is facing trial and in a criminal case, the previous good character becomes relevant. In criminal proceeding, the fact that the person is a good character is relevant. So in criminal case, not bad character is not relevant. Only that the accused is of good character, that is relevant in a criminal case. But section 54 is also, that is to be read along with the provision of section 53. What it says? Previous bad character not relevant except in reply. Now question comes, section 53 makes it, makes provision that in criminal case, the good character of the accused is relevant. Then whether bad character of accused is relevant. This is answered in section 54. What it says? In criminal proceedings, the fact that the accused person has a bad character is irrelevant. Bad character is irrelevant unless evidence has been given that he has a good character, in which case it becomes relevant. That means, as you know, in section 53 provides In criminal case, good character of the accused is relevant. When the accused gives evidence to prove that he has a good character, to disprove the allegation. So in such case, his bad character becomes relevant in reply to the evidence of good character. So this section 54 says, in criminal proceeding, the fact that the accused person has a bad character is irrelevant. That is the rule. The accused has a bad character, that is irrelevant unless evidence has been given that he has a good character, in which case it becomes relevant. That means when accused gives evidence to prove his good character in a criminal case, then his bad character becomes relevant in reply to his evidence of good character. So this explanation provides, this section does not apply to cases in which the bad character of any person is itself a fact in issue. What is that case? Suppose a person is produced before an executive magistrate to detain him under section 110 of the CRPC, that is habitual offender. So in such case, the bad character of the accused is itself an issue. So in such case, that bad character of the accused is relevant, because the explanation says this section does not apply to cases in which the bad character of any person is itself a fact in issue. In certain cases under the CRPC, that is preventive measures taken as per the provisions from 107, 108, 109, 110. So here, that the bad character of the accused is itself an issue. So in such case, the evidence can be taken. That is admissible. That is relevant, not irrelevant. Because general rule is that in criminal case, the bad character of accused is irrelevant. But when accused gives evidence to prove his good character, in reply to that, evidence is admissible to prove his bad character. But this is not applicable when the bad character of the accused is itself an issue in a criminal proceeding. For an example, in a proceeding under section 110 of the CRPC, that is an habitual offender, the police alleges that he is in the habit of committing crime, that is a bad character man, So in such case, that becomes relevant because the bad character is an issue, is itself an issue in that criminal case. The explanation 2 provides a previous conviction is relevant as evidence of bad character. So to prove the bad character of a person, the previous conviction of a person is relevant. So now, again, you go through provision of section 55, character as affecting damages. In civil cases, the fact that the character of any person is such as to affect the amount of damages which ought to receive is relevant. Then what is character? That has been explained in section 55. What it provides in section 52, 53, 54 and 55. The word character includes both reputation and disposition. But except as provided in section 54, evidence may be given only of general reputation and general disposition. Specific instance of bad character will not be given, that is general reputation and general disposition. But in section 54 it has been provided that when reply specific instance in which a person was convicted or a person had bad character, that can be given. Except as provided in section 54, evidence may be given only of general reputation and general disposition and not of a particular act by which reputation or disposition were shown. So now, this is in nutshell the relevancy of character as evidence under the relevancy of facts chapter. So now, by discussing after conclusion of our discussion, we have completed the provisions, that is relevancy of facts. So let us conclude. In our next class, we'll discuss the chapter 3, that is on proof, how a particular fact is to be proved. So thank you all.